welcome to today's webinar, which is all about private practice and what we think members need to know from a regulatory perspective or from AXLPA's perspective. So I'm Sharia Ali, I am the SLP advisor at AXLPA, and I'm going to be presenting today with Cheryl Blair, who's the audiology advisor. We just have our usual little spiel that we go through before we jump in. If you're having any technical difficulties, let us know in the chat and we can try to help troubleshoot. If you don't have the chat available to you, there's a phone number and an email address in red on this slide that you can contact us through, and we'll help problem solve through any technical difficulties there as well. As usual, this presentation is going to be recorded, and we'll make the recording and the slides available on the AXLPA website, and you'll get a notification when that's ready for viewing. So we're going to jump straight in. We have a lot of content that we want to get through today because today's webinar is actually, it's going to be different than the usual webinars we do at AXLPA, where we present on key college documents and changes to them, updates, etc. Today's all about private practice, like I mentioned. We know that private practice setting can present some additional considerations, challenges, complications to providing services. So we wanted to make sure that members are aware of relevant information and resources that they can use to help navigate the private practice setting. So first off today, I'm going to be going through some frequently asked questions that we get about going into private practice. I'm going to talk about a professional decision-making framework, and then I'm going to hand it over to Cheryl, who's going to take us through some key practice area considerations to always keep in mind. So the private practice FAQs that I'm going to talk about are actually taken from a professional predicament. And AXLPA's professional predicaments are sort of a practice advice series that we publish on our website. So the link to this professional predicament is on this slide. And later in the presentation, I'm going to take you to where you can find all of those professional predicaments. So first question I always get asked about from folks who are thinking about going into private practice are there any special AXLPA requirements for going into private practice? So folks will ask, do I need to get a special kind of practice permit, or do I need to get permission from AXLPA? And the answer is no, there are no special or specific AXLPA requirements for going into private practice. The understanding is if you hold a valid practice permit from AXLPA, you can engage in providing services in any setting, including private practice. Folks sometimes ask, well, is there a minimum number of years of clinical or practice experience that I have to have before I go into private practice? And the AXLPA answer is no, there is no minimum amount of time of clinical experience that you have to have. However, that might be a personal decision. Some folks might just feel more comfortable kind of getting their feet under them with clinical experience in a non-private practice setting before moving into private practice on their own. That's a personal decision. If you do go into private practice, we ask that you update your employment information on your AXLPA member profile that's online on axlpa.ca. Another really important consideration is making sure your competence is up to date if you're transitioning into a new practice environment for you, or if you're going to be opening up your client range to different sorts of clients. So for example, if you've never worked in private practice before and you're thinking about going into private practice, it might be a good idea just to spend some time researching the specific expectations, requirements of that setting, so you're ready to go once you set up your practice. Another example is if you intend to sort of open up your practice to all clients, including ones that you don't have recent clinical experience with, might be a good idea just to get yourself up to date through reading, continuing education, so that you're able to provide competent care to all the clients that you're going to accept. Another really common question I get asked is, do I need a business license? So as per the Health Professions Act, AXLPA regulated members aren't required to obtain a municipal business license to practice their profession, and AXLPA regulated members are also not required to incorporate a private practice. However, just because you're not required to doesn't mean that you can't if you wanted to. There might be disadvantages and advantages to either one of those things. And really, someone with expertise in those areas, like an accountant or a lawyer or even your municipality, will be the best source of information if you're trying to make decisions around, do I get a business license or should I incorporate? Folks also ask about insurance. So hopefully you'll all know that every regulated member of ACLPA with a practice permit, and when you want to renew it, you have to provide evidence of holding your own professional liability insurance. So that insurance requirement is consistent for all members, regardless of the setting that you practice in, and the specifics of your coverage are shown on the slide there. So outside of professional liability insurance, ACLPA doesn't have any other requirements specific to private practice per se. We know that there are other types of insurance that are available, especially to private practice owners, like cybersecurity insurance or office contents, etc. Again, these aren't required by ACLPA, but they might be a good idea for you and your business. Your insurance broker will probably be the best source of information on what will work for you. And just so that you have it there, there's a link to ACLPA's professional liability insurance requirements that's on this slide. So it's 2024, so I also get questions about using social media for business, or just using online tools for business. And those can be really important business tools for folks. And regulated members, of course, they're able to advertise on social media, use social media for business, but you must do so in compliance with all relevant standards of practice and the ACLPA Code of Ethics. Specifically ensuring that you're maintaining professional boundaries, integrity, client confidentiality, super important at all times. So whatever you're doing in an online medium, our standards of practice and our code of ethics are still going to apply to that. So with that in mind, it might be a good idea to maintain separate business and personal social media accounts. Also a really good idea just to sit down and kind of think out a social media plan or approach, you know, what types of things you're going to post, how often you're going to post, how you're going to respond to comments, etc. And even if you're not advertising on social media, it might just be a good idea to review our standard 4.5 on advertising and promotional communications. And there's a link to that standard on this slide. And I mentioned professional predicaments earlier. We also have a whole series on social media, and there's links to them on this slide, and I'll show you them later on in the presentation as well. Also a really good resource and might answer some of your questions about using social media for business. So we're going to jump into the professional decision-making part of the presentation. I forgot to mention in our little agenda that we're also going to have dedicated question time at the end. So feel free to pop your questions in as they come up, but we're probably going to save answering them until the end. So this is not the framework, but I wanted to expand on this concept because I think it's super important. Your professional decision making shouldn't only be a question of can I, like, am I allowed to do this? Is there a rule or a regulation about this? But also, should I? Does it feel ethical to do this? And those are two different questions. I wanted to expand on that a little bit today for you all. So when I say, am I allowed to do that? That means, is there a regulatory requirement, like something from ACLPA that says I'm allowed to do this? Is there an organizational policy, or is there a piece of legislation that says I'm allowed to take this action or I'm prohibited from taking certain actions? So hopefully, let me just get my little laser pointer ready here. Hopefully, a lot of what we do is in this box. Things are allowed, so there's a rule, and also feels ethical, feels right to do it. And hopefully 100% of the time, we can stay out of this box. So things that are not allowed, and they're also unethical. So if you're operating in this box, hopefully you get in trouble with somebody, maybe the college. So those are sort of clear-cut situations. Sometimes, though, you might be over here where technically something's allowed, but you don't know if you should. It doesn't feel totally ethical to you. One example is using standardized assessments in English for linguistically diverse clients. A funding agency or your contracting organization might say, yes, we need these scores on your reports, please. So technically it's allowed, they're telling you to do it. But we know that these types of assessments aren't appropriate for all clients. So then you have to sort of consider, well, should I do this? Is it appropriate to the client? And you're really going to have to look at the specifics of the situation to make that decision on should I. On the other end of that are situations where something is maybe not allowed by the rules, but feel ethical to you. So one example I can think of is treating friends and family. So ACLPA's therapeutic boundaries guideline has sort of a general recommendation against engaging in providing services to friends and family. However, the guideline then goes on to say, well, here are some situations where it might be allowable or it might be okay. For example, if your family member didn't have any other service provider available to them, and you also felt like you could properly manage the potential conflict of interest, then that situation might feel more ethical to you, even though there's sort of a blanket recommendation against it. So you can see in both of these situations, in both of these boxes, the context is really important. The context might be the deciding factor on should I or should I not. And so, yeah, it's really important. There might not be a clear, hard and fast, yes or no, champion of champions, most correct answer. We're really going to have to think about the context also the context of what are the rules around the situation. So I think, and this is coming from someone who's never worked in private practice, that decision-making in private practice can sometimes be complicated by a couple of things. So the first is that depending on where you work, you might not have an employer's like huge legal or administrative or HR departments to rely on. Sometimes the buck stops with you. You have to know the relevant obligations on your practice. So college requirements, legislative requirements, other rules and policies. You have to make sure your practice is consistent with all of those things. Also, there is a potential for completing obligations. So we're not asking you to provide services out of the goodness of your heart for free. Your private practice is your business, it's your livelihood, and inherent to that is there may be some personal interests that are existing alongside your professional interests in that case. And whenever that's the case, there's a potential for conflict of interest to occur. Also, I think that there are additional aspects to think about when you're in private practice that, you know, someone like me who worked for a school board, you know, didn't ever have to think about. Like if someone needed to be recruited or hired, I didn't have to think about that at all. In private practice, you might be doing all of those activities or managing the materials in your clinic or, you know, being in charge of fees and billing, etc. So with all of that in mind, I just wanted to talk about some steps for decision making, for professional decision making. That you can use if you're ever in a situation where you're still contemplating, oh, can I, should I? So first is gather data. So remember I talked about context can be really, really important. So you want to just pull up all the relevant information that's applicable to the situation, take a full case history on the context of the situation. Next, really importantly, and Cheryl will go through some practice areas where this comes up a lot, is considering the client. So the client is actually the one that has the most to lose or gain from any decisions that you make about their care. So they have to be treated as an equal partner, and we have to take steps to try to understand their perspectives and be sensitive to their needs and how the outcome is going to affect them. Next, super importantly, you're going to have to analyze your interests and obligations. So first on there is personal values. And some people might be shocked to see personal values on there as an interest or an obligation. I think there's this myth that we're healthcare providers, we're supposed to be totally neutral and totally objective. I don't think that's ever possible. And when we're thinking about private practice, your business, your livelihood, of course you're going to have some personal interests or vested interest in the outcome. That should not be the driver of your decision making. Your personal value should not be the driver of your decision making. But you do need to recognize that they can influence your decision making. So I think just some awareness that you do have a vested interest in the outcome and that it might try to take over with your decision making is a good way to avoid having that happen and to limit the impact of your personal values on your decision making. Of course, you're also going to have to look at what your regulator says. So looking at ACLPA standards of practice and our code of ethics. You're going to look at any organizational policies that apply to you. So, of course, in private practice, you're sort of making the policy for your practice. But if, say, you're partnering with an organization or you're contracting for an organization like FSCD, sometimes, a lot of times, those organizations will have a policy or a procedure or some kind of guidance for the situation that you're thinking about. So be sure to also check with any organizations you work with, see if they have a policy that can help your decision making. And of course, you're also going to have to be aware of any relevant legislation that applies to this situation, like tax legislation or privacy legislation. Those are just a couple of examples. So once you have background information on the context, you have the client perspective, and you know what your interests and obligations are, hopefully you can mash all of those together and find some options that you can then choose from. And as I mentioned earlier, sometimes there is no one yes or no most correct answer. So the situation might not be solvable, but hopefully it's resolvable. There is an appropriate way forward for you. So I wanted to give you some tips to close off my part of the presentation on how to use that framework. So remember, step 3 was analyze your interests and obligations. I think a really important tip is to know where to find correct information on your interests and obligations. So everybody write this down. Just because someone said it doesn't mean it's true. So regulated members, each regulated member is obligated to know the current, up-to-date, correct, professional, and legal requirements on their practice. So it's up to you to know that and ensure that you're working off, for example, the most recent standard of practice relevant to the situation or the most recent guideline relevant to the situation. And to do that, you can always check with ACLPA for your regulatory requirements. Call or email Cheryl or I. That's part of why we do this job, is to respond to those types of inquiries. Our website also has a lot of great information, and I actually just want to go there now because I thought while I have everyone here, I can just show you the spots you should be checking. So we're on aclpa.ca, and on this menu that runs across the top, we're going to go to menu and member, and key college documents. So I think this is the first place you check if you're looking for regulatory requirements on your practice. And in that, I think the first place you go is to the standards of practice. So they are all organized in sort of different categories, or we call them areas. But scroll down, look at all the titles and the little blurb on them and see if anyone's jumping out at you that's relevant to your situation, and take a look at it. And, if you're having difficulties just sort of, understanding sort of language around it or how it applies to your practice, again, give Cheryl or myself a call and we can talk them through with you. So if we go back to key college documents, there's a standard of practice, code of ethics is on there as well. If you scroll down, there are lots of supporting documents that we also have, like our guidelines and position statements, etc. Another place to look is, I mentioned those professional predicaments. So again, under members, we're going to go to communications this time. And here are all of the professional predicaments. So these are typically written when there's a lot of questions around the same topic or theme. We write up a professional predicament about it. So I think it's a really good resource. Take a look through them if you ever have a question chances are, if you have a question, someone else has had that same question, and if enough people ask that question, we write a professional predicament about it. So I think a really good resource here as well. So there's lots on fees and billing. Here's our social media series, so be sure to check here out as well. If you wanted to see a list of legislation that might apply to your practice, you can go to the college in that top menu and governing legislation and bylaws. And this is, scroll down, this is a non-exhaustive list, and it also has links to particular pieces of legislation that might apply to your practice. So I'm going to close that out and go back to the presentation. Just wanted to mention that if you are contacting AXLPA, just be mindful that there are some limits to things that we have the expertise or authority to comment on. So things like employer-employee disputes or insurance codes, etc. We really don't have the expertise to comment on those types of things. I've mentioned legal requirements quite a bit. You have to be sure that you're keeping up to date with legislative requirements. Might be a good idea to just research which pieces of legislation are applicable to you, and someone like a legal counsel or someone with similar expertise can help you sort of interpret how they might be relevant to your setting or your practice. Another tip is to think about reasonableness. So that is a concept that there are many different ways to accomplish the same task. So reasonableness doesn't ask for what is the most correct champion of champions supreme answer. It simply asks, what would a reasonable clinician do? So in private practice, in your decision making, sometimes what you decide on as a route to go forward might not be what another clinician could do or would do. And that's perfectly okay, as long as what you've decided to do is reasonable to the situation. If we can look at it and say, okay, that is what a reasonable clinician would do, you've done your due diligence. And if you're ever in doubt, contact the college. So my last tip before I hand things over to Cheryl is to find a network. We know from a lot of the work that went into the continuing competence program that professional isolation is a risk actually to competent practice. And I would also say it's a wellness risk. We all need opportunities to discuss, to problem solve, get advice, stay current on research and resources, and also to vent. So no one can know everything. Everybody needs help at some point. So we really encourage you to find at least one other professional that you can reach out to whenever you need to talk through a situation. And with that, I will hand things over to Cheryl, who's going to take us through some key practice areas to consider.
Okay, thank you, Sharia. Okay, so first in the series of slides regarding key practice areas is the one on fees and billing. I just have to move my cat. I apologize, but she is messing up my plan here. All right, sorry about that. Okay, I just have a situation, technical difficulties, but I'm coming through. Fees and billing. Okay. Regulated members must ensure that the fees charged for products and/or services are justifiable, of course. There's also a requirement that regulated members fully disclose the fee schedule for products and/or services, including fees for assessment and intervention, reports, equipment, and any other associated costs. Fees should be disclosed prior to providing services, as regulated members also have an obligation to obtain and document clients' consent for fees prior to the service delivery. Research shows that insurance fraud, intentional and unintentional, is one of the most common ethical dilemmas encountered in private practice. As such, once services are provided, regulated members are required to provide clients with accurate and detailed invoices regarding fees in a timely manner, maintain accurate financial records related to fees and services provided, and correct any fee or billing discrepancies in a timely manner. When signing contracts with third parties, ensure you're familiar with what is covered under the contracts and the policies and procedures surrounding their contracts. For example, understand what is covered and what is not covered in the contract, so you're not requesting equipment that is not covered. Take responsibility for counseling clients appropriately on their coverage and eligibility for benefits rather than throwing the responsibility back on the third party. For example, if a client loses equipment, explain that lost items are not covered and remind the client that they signed a form acknowledging that when they received a hearing aid, for example. Next slide. Thanks, Sharia. Okay, let's talk about termination of services. So the decision to withdraw professional services should not be made without good reason. There are several legitimate reasons for discontinuing services. For example, if the professional is relocating or closing their practice, or if the client is non-compliant with the treatment plan. While there is nothing inherently unethical in terminating services for valid reasons, discontinuing services in such situations may result in the client being left without appropriate care. Termination of services should be appropriately planned to ensure that the process is safe and ethical. Some considerations when discontinuing services are shown on the slide. So you'll have to think about discharge planning and facilitate client participation in post-discharge care, referrals, etc. You can do this by assisting the client to find another practitioner. ACSAPAW has a find an audiologist or speech language pathologist tool. Provide them with 2 or 3 names for follow-up, and you can assist with file transfers. You want to think about how the decision is communicated to the client, so explain the reasoning and discuss next steps. Give your client adequate notice of termination so that they have sufficient time to arrange for service continuity. And you want to document the reason for discharge and document your discharge planning activities. So remember, it is considered unethical to deny or discontinue services on a discriminatory basis. This includes protected grounds under the Alberta Human Rights Commission. So, for example, race, religious beliefs, gender identity or expression, age, source of income, etc. While mental and physical disabilities are also considered protected grounds, it is not unethical for a regulated member to discontinue services for a client with a disability if the SLP or audiologist lacks the necessary competence for working with that particular disability. And you can change the slide, Sharia. Thank you. Okay, let's talk for a minute on documentation. So in the hustle of a busy day, I think we all know it can be easy to forget to document specific aspects of a session. Documentation is a critical aspect of a healthcare professional's responsibilities, as it serves as a legal and professional record of the care provided. So what do you do if you're faced with a client who did not receive a follow-up appointment because there was no documentation to indicate that one should have been made? So in a case like this, you may be faced with an ethical dilemma regarding how to handle the situation and address the potential impact on the client's care and satisfaction. So possible resolution steps could be transparent communication. You can just acknowledge your mistake and explain the oversight and documentation and take responsibility for the confusion and the inconvenience. You can provide corrective documentation. And so while it's not possible to retroactively document the initial session, you can create an addendum to the client's record detailing the information that was initially omitted. And this ensures to provide a comprehensive and accurate record moving forward. You can, of course, go ahead and do a reassessment or a readjustment of hearing aids, for example, if the previous results were not recorded. You don't want to be making them up. You can just go ahead and repeat them. And think about professional development. So you can use this experience as a learning opportunity, an opportunity for professional growth. Maybe take some training on organization and effective documentation practices if you think that might be helpful to prevent similar oversights in the future. You can also just do a review of your policy, assess your current documentation procedures, and if necessary, work to implement improvements or reminders to ensure comprehensive documentation moving forward. On another note altogether, keep in mind that there may be some legal responsibilities in addition to legislation. For example, if you're building an electronic medical record for your practice, Our standards of practice alone would not suffice in terms of what you need to know and be compliant with. So you would need to look at privacy legislation to understand all of the requirements. Okay, we'll move ahead. Thanks, Sharia. And speaking of privacy and confidentiality, remember that privacy and confidentiality for the client must be maintained when financial records are to be viewed by anyone other than the service provider, the client, or the client's authorized representatives. So in situations where there is a third-party request to view financial or administrative records, fully redacted or summary records should be provided. So that means the records redacted or summarized should be done so in a manner that meets AXOPOS standards of practice and protects client privacy and confidentiality. All right, next slide. So let's talk a little bit about managing difficult conversations. So you may, and you probably will, encounter situations where you must balance respecting client autonomy with your professional responsibilities, where your communication with the client is going to be a critical aspect in successfully navigating this type of situation. Let's talk about an example here. What if you have parents of a pediatric client express concerns about the cost and the time commitment required for continued therapy? You understand the financial strain on the family. However, you also know that additional therapy is crucial for the child's long-term speech development and overall well-being. So in this case, you face an ethical dilemma regarding informed consent. You feel obligated to advocate for the best interests of the child and to inform the parents about the potential consequences of discontinuing therapy. On the other hand, you know that pushing for continued therapy may create additional financial burdens for the family and might strain the therapeutic relationship. In this situation, you have to navigate the balance between respecting the autonomy of the parents and ensuring the child receives the necessary care for optimal outcomes. You must decide how to communicate the potential risks of discontinuing therapy, while of course being sensitive to the family's financial concerns and obtaining informed consent for the best course of action. So what are possible resolution steps? You could have open communication with the parents and discuss their concerns, acknowledge the financial constraints, and share professional perspective on the importance of continued therapy. You could include collaborative decision-making, involve the parents in the decision-making process, presenting alternative options such as reduced frequency of sessions, exploring government assistance programs, or providing resources for at-home exercises to complement the therapy. Informed consent documentation, regardless of the decision reached, ensure that the parents fully understand the potential consequences of their choice, and this may involve documenting the discussion and the parent's decision in the informed consent form. And of course, there is the option of referral to other resources. You may be able to refer the family to local support groups, community services, or government programs that can provide financial assistance or additional resources to help the cost of therapy. And you can also consider referral to a publicly funded agency for ongoing follow-up. Next slide. All right, let's talk a little bit about child-centered care. So I occasionally encountered situations in my 23 years of owning a practice where I was faced with having to stay true to client-centered care, even when it was very difficult for me. I thought I would share a few of these situations that still stand out in my mind. So in the first situation, my client was elderly, spoke another language, and was accompanied by her family who had immigrated from another country and who spoke for her. She came into the initial visit wearing a body hearing aid, so I assumed she had a profound hearing loss. For those of you who don't know, a body hearing aid is an old-style hearing aid consisting of a box worn on the body with a belt or strap, with wires attached to receivers and ear molds worn in each ear. The actual hearing aid itself was, by today's standards, basically just an unsophisticated amplifier. These hearing aids were used in the 1920s and 1940s, and they were still sometimes used after that for profound hearing losses. I did not see many of these hearing aids in my career, although I did see a few, and I wonder if you could even find one now. After assessing this client's hearing, I discovered that she had much less hearing loss than I expected. I spoke to the family of the options they could consider for more appropriate amplification. I did not get very far with this, however, when I was cut off by the family, who indicated that what the client had was just fine. Now, I had an immediate emotional reaction to this response from the family. I had all sorts of judgmental thoughts running around in my mind that I can still remember. In the moment, however, I had to contain my negativity and stay understanding, accepting, and professional. It took quite a long time for me to think about where the family may have been coming from, what they may have been up against, and what factors may be influencing their decision. And looking back, I wonder if I could have been more open and if there were ways I could have facilitated more conversation. Even now, though, I realize that my goal would have been to fit a different kind of amplification because that's what I thought was best for the client. But would I have been right? I could only think from an audiologist's perspective. I knew nothing about the family and about my client's day-to-day life. The second situation I thought I would share is one I remember quite well. I diagnosed a little girl with a hearing loss and was proceeding with fitting amplification. And although this was quite some time ago, I remember her parents vividly. They were both professional people who dressed very, very stylishly, and they each wore boldly colored designer eyeglasses. At that time, colored ear molds and hearing aids for children were fairly new and very trendy. I immediately assumed, incorrectly, that the child could choose a colorful set of hearing aids and ear molds for herself. I very mistakenly showed the child the range of colors to choose from without consulting the parents first. They were horrified and immediately stepped in, telling the child that it would really be best to go with the plain neutral skin tones. I was taken aback and realized that I had not obtained informed consent before proceeding with options and that I was in the wrong. Although I sincerely apologized, I felt very judgmental towards them, thinking they were denying their child the opportunity to wear fun colors as well. It took me much longer to realize that these parents were likely in the throes of trying to accept their child's hearing loss and were perhaps just trying to protect their child. It still makes me emotional. I thought that was worth sharing. Okay, next slide. Human resources management. Okay, so this might be surprising to you, but AXAPAL also has some minimum standards with respect to human resources management, which apply to any employees and also contractors. What we wanted to bring your attention to in this webinar is the minimum requirement for inclusive supervision or management. We'd like to remind you of the obligation for respectful, sensitive, responsive, and accommodating management, particularly of folks who may have already faced some degree of marginalization in the workplace. This includes consideration of cultural and linguistic diversity, neurodiversity, and disability, among other factors. So it's beyond the scope of this presentation to delve into inclusive management properly, but we wanted to flag being mindful of power dynamics and practicing cultural humility and self-reflection as tools that can promote respectful and responsive supervision. So when you get a chance, please review this standard on human resources linked on the slide if HR management is a part of your practice. Next slide. Okay. So lastly, what about closing a practice? We wanted to remind you about considerations when closing a practice, and remember that it is most of the considerations for starting a practice also need to be considered when you close a practice. So for example, closing your website, closing any accounting and legal actions or steps you took, and thinking about how you retain and store records for the stipulated periods. So remember to shut down or close anything that you originally set up for your practice. Next slide. So we've put together, actually Sharia put together for you references and resources that might be helpful. And those, of course, you'll be able to find when this presentation is published on the website. And next slide.
Just make a note that the references and resources are mostly around the professional decision-making framework that we chatted about earlier.
Okay, thanks, Sharia. Actually, I'll just hand it back to you at this point.
Okay.
Thank you.
So we have some time to go to questions.